Thank you everybody for being here, and we're really looking forward to hearing Rohin on the idea of love law and the Constitution, as well as in particular about his book. And we also look forward to having a kind of discussion or some kind of thoughts from you all as well. So we're thinking of doing it roughly this way. Half an hour we'll have some general sharing of thoughts on the ideas. What do you mean by why did Rowan come up with the idea of love law and the Constitution? What is the importance of that idea? Then we'll go into looking more particularly at his book and have a couple of questions, thoughts, provocations.
You got a 5-pager dossier on my book, so I'm quite intimidated, if I may say so.
Just simple notes. And finally, we'll open it out to you all guys, and any thoughts you have, we can come in. Yeah, and we'll try and keep it as informal as possible. And so please, at any moment in time, if you feel you'd like to come in as well, please do let us know if things are not clear, or you'd like something explained better, etc. Yeah, and so without further preliminaries, Rohan, the idea, I mean, I was very intrigued and very interested in the idea of love, law, and the Constitution, right? And we often don't think of law and love together. We think of the law and the Constitution together. But the idea of love, law, and the Constitution coming together is to me, it's a very fascinating and very intriguing idea. I'll come in with some of my thoughts later. But first, you're the one who came up with this wonderful idea, which I really like, of thinking of law, love, and the Constitution together. So maybe you can tell us a little bit about what these ideas are about.
Well, so, let's start with the basics, right? India is a republic. One of the most common truism is that India as a republic is founded on the idea of love. These are themes that keep on occurring frequently in popular discourse. But the question is, are people free to love who they want, irrespective of caste, class, gender, religion? And the answer to that in today's India is a no. And not just today's India, the answer to that has historically been a no. Maybe the factors have changed. Maybe the way the law uses suppression as a means to defy love has changed. But the law and love have sort of always been in conflict with each other, right? If you look at the US, you have your anti-miscegenation laws, and then they finally end in Loving versus Virginia. Or if you go further back, right, to the idea of Saint Valentine's, who was marrying couples when Claudius the Cruel said, no, you can't marry a person you want. So this idea of love as defying not just law in its traditional positivist sense as we understand it, but in its sense of social control, as a form of social control, is an idea that I've been grappling with. Now, for those of you who have read the book, you know that I was almost arrested for kissing a boy. I don't know why, for it's the most fun thing I usually do in my life. But to find that one of these, rather inane acts as they were, would end up in me being in a police lockup, and God forbid, if we weren't able to bribe the policeman that day. It kind of put me in this quandary of thinking about these complex associations of law and love. But you see, as lawyers, we are also taught to think about the law clinically. Social sciences, on the other hand, do talk a lot about the intersection of law and emotions. Few lawyers do, Martha Nussbaum being one of those. But in hardcore litigation, in hardcore legal practice of navigating one's life, the law often becomes a hindrance to what the Supreme Court called the promise of equal citizenship in Naftage. Now, we've been told by the court that right to love is a fundamental right. But what the court does not do is spell out what it means to be loved or what it means to love, right? And we're seeing that across the board in the kind of litigation that is coming up across the country. It's not just about queerness, it's also about heterosexual love. The debate around marital rape, for example, is it not an intersection of love and the law? The recent, media trial of Atul Subhash and his wife, is that not an intersection of love gone wrong and its intersection with the law? So I think I've barely scratched the surface with this one, and I think I don't think I can do it justice in at least one book.
Thanks, Rowan. I think what is really interesting is there are, from Rowan's description, there are many ideas of the law and possibly many ideas of love. And you think of the law, right? And often, I mean, the poem I think, which I was very inspired by actually, is W.H. Auden's Law Like Love, right? And I think I want to just quote a little bit of that for you. See, Auden asked the question, what is law, right? And he says, is law the wisdom of the old? Is it the words in my priestly book? Is it according to the judge, law is the law? Or is it according to others, our fate, our state? Or is it according to the wishes of the loud, angry crowd? Is law we or is law me, right? So the many, in Auden's understanding, the many ideas of law. But the point he comes to, which is really interesting, in the end he ends by the argument that law like love. And I think that's, in a sense, the thematic which Rowan is exploring, is when does law become like love? And again, what you think of love, right? I mean, okay, when does law become like love? Maybe to add to one of your points, is we think of the Constitution, I think, as a document of deep political morality, founded fundamentally, I think in Rowan's words, on the idea of love. And you go back to some of the great human rights lawyers in the Indian context, Kannabaran talks about the Constitution as a document which emerges in the context of a struggle as emotion recollected after tranquility, right? And so there's a way in which you think of the Constitution as embodying, in your words, the largest, in a sense, the politics of love, as it were. So that's one kind of an idea of law, like love. But then again, love, I'm sure you're going to tell us in greater detail, is a very, I'm sure everybody in the audience can tell us in greater detail as well, is a much more complicated emotion. There are many dimensions to it. Love can be an act of possession. Love can be an act of connection. Love can be an act of despair. Love can be many, many things. So when you say law like love, what is the law and what is the love that one is really thinking about? I'll just add one more thought to it. I mean, in terms of thinking it back to the context of the litigation, and how do you think of law and love in the context of the 377 beginning point litigation, right? Initially, the law is not love. The law is something which suppresses love, which is, of course, 377, and Rowan has made the point again and again. His kissing story is that. What does the law do? It prevents love. It inhibits the expression of Rowan's affective, emotional self. So there's a way in which the law controls love, as it were. But what was intriguing for us is when it got to the Delhi High Court, you saw the law differently. Law became like love, wherein you had the idea of the question of Justice Shah and Justice Mullidhar basically making the point that the law must recognize the right to love. Then, of course, we have the what is love without an act of betrayal, right? And 2013 is the law betraying you, like like our loves. I can speak to maybe many people in the room, often betrays us, right? And so 2013 is a bad day for law and love, with a certain kind of a betrayal of the deep love which the law initially showed. But then, I mean, betrayal doesn't often end as betrayal. Sometimes there's reparation. And arguably, in 2018, there was law as reparation and love as reparation, where you had the return to the idea of law like love. And then we, of course, come to the thematic of your book, which is 2023, where it seems to be, in my reading, a betrayal, of course, also the promise of a future love. So, any thoughts on this kind of thinking of law and love together?
especially in context of the Supreme Court, in my book, I use the analogy of it being a fair weather friend, where when the government has not pushed back, the Supreme Court has ruled in favor of the community. But I think looking at a broader schema of how the Supreme Court has adjudicated on rights, I think it's like a toxic lover. It dangles a carrot in front of you only to hit you with a stick, right? You go to the Supreme Court in 2018 and boom, you have these huge promises made over a tome of judgment running into over 350 pages. So, you go to the lover, ask for a kiss, and you get a whack. You get told that, well, there are institutional limitations on what we can do. And the same judges that tell us that there are institutional limitations to us legislating, a few hours later and a few days later, do the exact opposite and legislate, right? I'm talking about the Balram Singh judgment. And Justice Ravindra Bhatt wrote the majority judgment, where he said in Suprio that, well, we can't, we can't legislate, but then he goes on and legislates on the issue of manual scavenging. Now, I don't begrudge him doing that, but there's also this institutional duplicitousness, much like a toxic lover, that dangles a carrot, and as soon as you go towards it, you end up in that cycle of violence again and again. And so I say at the end of the book that the answer to break free of this chain of violence, there must be a popular struggle for love. And that popular struggle for love will take a village and will take a country in this case.
I think with that kind of a broad background, which we've kind of hopefully painted on the idea of the linkages of the connections between law and love, which I'm sure all of you guys have many more thoughts on. I thought you already got to it, but maybe get a little more into the question of the book itself, right? And that's what you guys all hear. And maybe give you a bit of an introduction to the book and why I think it's a very important book, right? When we think of cases on love, which is not accepted by the law, there have been a number of such books. Give you a couple of examples. Rohan mentioned the question of, in the United States context, the case of Loving versus Virginia, which was a case of a black and a couple with a black woman and a white man who got married against the law which prevented blacks and whites from marrying, the anti-miscegenation statute. So they were arrested, the case goes up to the court, and finally you get a decision. End of it, there's a really beautiful book written called Tell the Court I Love My Wife. Again, you get the affective, emotional power, right, of what the case actually meant. Then in the US context, the decriminalization judgment in the US context, which is Lawrence versus Texas, there's a book written on that called Flagrant Conduct. Again, it's a kind of a beautiful documentation, really, of the story of the one petitioner. And if you think of the Indian context, very often, lawyers know the names of many cases, right? If you ask any lawyer, they'll talk about great cases, Keshav Nanda Bharati was Union of India, maybe Navtesh Johar, Union of India, etc., right? But you ask anybody, who is Navtesh Johar, the answer may not be easily apparent. Keshav Nanda Bharati, the answer may not be apparent at all. So there are a range of ways in which we actually don't know the petitioners in the cases before the Indian Supreme Court. Whereas in the US, they've done a lot more work in talking about what you call a people's history of the Constitution, where you get a sense of who the petitioners were, what their stories, lives, loves, etc. were, right? And Rohan's book actually, I think, breaks a little bit of that tradition, right? Because here you have a book which is two very brilliant things it does. One is Rohan is writing both as a lawyer who's litigating this particular matter. He's also writing as a queer person who is experiencing the proceedings in court. And if you read the book, there's a certain kind of energy which comes in the two really coming together. Right? There's a way in which Rohan is able to bring together a certain kind of as you I'm sure realized by now, certain kind of a lawyerly imagination, a certain way of framing things in terms of the law. At the same time, Rohan is not shy or expressing his emotions or his feelings on a range of issues. So that power the book has. And so I think it's totally worth reading for that. That's one. The second point why I think it's a very important book is we all know books take a long time to write, right? And 2023, the judgment comes out and the book comes out in less than a year? A little more than a year? Less than a year.
Book was launched on the 17th of October 23, which is 1 year to the day of the judgment.
First anniversary, you have this book coming out. So just as a feat of authorship, I mean, a question of discipline, I'm really appreciative. I mean, this is really fantastic work. The fact that you pulled this together in such a short period of time. The other important thing, why I think it's important, right, is two other important reasons why I think the book is important. See, the books I mentioned in the past, be it Flagrant Conduct, Dale Carpenter's book, or Tell the Court I Love My Wife, they're written by maybe, I think, sociologists, anthropologists, maybe legal academics. The cases happened, they've gone and traced people and written that story together, right? It's a story which is often told, sometimes the way you put it, at the end of a battle. The battle is done. So we're going to tell you how we won this particular victory, right? Rohan's not telling you that. Rohan's saying that, we're in the middle of the battle, right? So there's something, I think there's a greater immediacy, greater importance than books which are written at the end of a process. This is in the middle of a process. And that links back to something very important. Because, again, going back to one of my favorite thinkers, Hannah Arendt, she says this in a translation of Tocqueville. She says that when the past ceases to shed its light upon the future, the mind of man wanders in obscurity, right? So the other reason, other than the question of great appreciation for the fact that Rohan has done this book, why I think this book is very important is it is about the past, even if it's the immediate past. But understanding that past might be very crucial for the future that we imagine in front of us. So the past in terms of, the questions of, as a participant who was a part of that entire process, what do you see that you think went wrong? What do you think we could have done better? What do you think are the gaps, maybe the points which we could or should have considered in the entire litigation process? There are 2 points maybe. One is in terms of the many points. One is the entire question of I think you read the book, okay, you'll get a good sense of it. Rohan is a litigator with a strong sense of, and I would say an alternative imagination, where he sees the limit points of litigation, and where sometimes you need another strategy. Sometimes the law is like love. Other times the law is not like love. Which case you need to go to where love actually is. Which is you need to go to maybe a people's movement. Maybe you need to go to street level protests. Maybe you need to think of working with other social movements, a range of possible strategies which should have been considered. Again, I think there's a space for that kind of, what the book opens out is both a documentation of what happened, which is really fantastic. I mean, you read that story of what was it like to be a litigator, that questions we should ask Rohan for sure, right? But the second part of it, which is what I think is very important, is it also opens out a path to the future. Saying, hey, this me could have been better, this was wrong, and this is where we kind of messed up. That both dimensions the book has, right? So just on these thoughts, do you want to just come in?
Well, I think it has to start by saying mea culpa. I think any sort of introspection has to start with admitting where we went wrong. I think that was a primary motive, one of the primary motives for writing the book. And there are a series of things that went wrong. It's a perfect shitstorm, as it were. The court is only one part of it, right? We did not have a campaign to sustain the kind of blowback that we were getting from the broader press, from, uninvited guests to the marriage, as it were. People like Bar Council of India, the Supreme Court Bar Association, who generally don't comment on ongoing litigation, but thought it fit in this case to comment on it. And then, Article 123 provides that Parliament will not comment on any ongoing cases. But you had legislators like Sushil Kumar Modi getting up in the Rajya Sabha and then, going on a tirade against marriage equality. So all of this happened. And one of the places where we went wrong is that we did not have a strong counter narrative. Second thing that I think may have gone wrong is the live streaming. So much of this being beamed into people's bedrooms, dining rooms, so those clips going viral at the end of the day led to information, but it also led to misinformation. One of the clips that went viral was the Solicitor General reading off of a random website what different kind of genders were. Right? So he said stuff like, well, there are genders where people's gender identity changes according to their mood swings. There are genders where people identify as male on odd days, even days, and something of that sort, pulled up from a random website on the internet with no scientific or sociological backing. And then to not be able to prove and to fight back on that issue. One of the things in response to that we did is that we gave them what is called a gender unicorn. Now this is used to teach students of the age 7 to 10 what gender identity and sexual orientation are. Now, so it's a very cute cartoon which tells you what gender identity is, your romantic attraction is, what your sexual orientation is, so on and so forth. One of the things that stood out for me was this senior lawyer. We passed on across the bar saying, here's a copy for you. He tossed it. He said, no, well, this isn't fit for a courtroom. Now that senior lawyer gets up to argue in Surrey Joinder. And the first thing he does is that he makes a basic mistake between gender identity and sexual orientation. Right? So I think a lot of people on both sides of the bar, not just on the sides of the union, but also on our side of the bar, were not thoroughly trained in what the nuances of gender and sexuality were. So for example, you have one of the lawyers on our side getting up and saying, well, you only have to deal with two categories, male and female, everybody else is a theoretical category. Forgetting that there were people in the court who were trans, forgetting that there were people on the petitions that were trans, and so the court could not leave that question open as a mere academic issue. And finally, I think, of course, the most important thing is that a sustained movement. After Koshal came, there were a range of pride marches with one singular theme, that we are not going back. And that sort of proved its way into, people showing up every year for pride marches, people showing up every year for protests against 377 and so forth. But post-Koshal, we've not been able to do that. We've not been able to do that for Transact. We have not been able to do that for marriage equality. We have not been able to do that for other broader issues in the community, right? Stuff like Garima Grace and so on and so forth. So the problem is, is that the queer movement is sort of this, again, going back to your original allegory of love, a polyamorous relationship, right? You have multiple lovers, all of them vying for the attention and love of a primary partner. Your partner here is the Supreme Court. You're asking the court, and most often the Supreme Court, to adjudicate on issues. We don't have the legal bandwidth to take all of these issues to court as once. Nor do we have the resources. Nor do we have the court time. There are 2 crore cases pending, right? So the idea also has to be to figure out what are our litigating priorities. Now, how do we do it, right? I think here a lot of anger is misdirected towards the lawyers in the marriage equality case. Part of it may be warranted, but a lot of it isn't warranted. Until now, in the history of the Republic, save for the first 1, 2, or 3 years, the fact that we've gone from filing of the petition to the final judgment of an issue that was supposed to be considered by a bench of 5 learned judges of the Constitution within the span of 10 months has never happened. Not when the court, in its initial years, when it was a federal court dealing with, say, 3 or 4 disputes a week, But to imagine that this case would be, this would be bulldozed through the remaining of the pending cases was something that took a lot of us by surprise. Now, why did that happen is a question for the person who was then the master of the roster. But I do believe that, lawyers in part have to say that we did wrong when we did not show up to the protests for Transact. We did wrong when we did not have the stellar galaxy of lawyers appearing in marriage equality, not appearing in other issues. And that is not to take away from lawyers who appear in other issues, but I think it goes to their credit that despite these causes not being quote-unquote media savvy, they've made themselves available and they've been there doggedly pursuing those cases in the absence of any fame, right? Like I say, that marriage is sexy, marriage is Instagrammable, right? It gives you good aesthetic. The rape and murder of a trans person does not. It gives you gory details that people often would like to shy away from. So I think it's a lot of things, a lot of introspection that we have to do as a community, a lot of introspection that we have to do as a movement. And the best thing lawyers can do is to pass on the mic at this point.
Again, so many thoughts you've opened out that I want to go down all those routes, but I'm trying to think of what is the. Let's take one thing at a time, right? The question I was asking Rohin is, in short, right? Why did we lose in the Supreme Court on this point, right? And the argument on the other side, of course, is that this was the best time to litigate this matter, right? This is the best time because we're the most empathetic and the sympathetic judges possible. You're not going to get a Chief Justice Chandrachud with all his Navtej thinking back again. So this is the time, this is the short window you have to get it done, right? And Rohan's response to that is to say that sure, you think of it within the terms of a litigation strategy, but a litigation strategy is embedded in a wider social and a political context. And the wider social and political context is a context which doesn't fully understand the idea of marriage, either between two men or two women or trans people getting married. It just doesn't fully understand that. It takes time for society to understand and accept that these realities do exist. Take the contrast, right? In 2001, it wasn't obvious that that same-sex relationships were not unnatural. It took a long period of time in terms of, as Rohan rightly put it, protests on the ground, saying 377 should go, saying saying that what is unnatural is the law, things on those lines, and parents of LGBTQ people coming on TV and making the point that what is unnatural is a law which criminalizes my children, right? All of this brought about that transformation or the shift in the way society thought about these issues. And marriage, by contrast, as you rightly indicated, 3 years from beginning to end, you didn't have that time to educate society. Again, my own perspective on this is we think of law and society as really maybe two strands of a double helix, where one influences the other. And so there's a way in which when you're doing a courtroom argument, you're trying to see how does this help in changing a larger public opinion. And that's very, very important. And I think the problem we faced here, it was too short a time period.
Well, I don't necessarily disagree with that. I think it may be so. Assume that it was 3 years, right? The question that we must ask ourselves as a movement is, did we do enough in those 3 years, right? But more importantly, the question that we must ask the court is that did it stick to its own previous jurisprudence, some of it given by the judges that were on the bench, the so-called progressive judges, quote unquote. These petitions were filed within 2 months of the Chief Justice taking office. Now, had we waited for 6 months more, he would have perhaps not done that, right? But then, again, I don't think it's only fair to blame, it's only fair to point fingers towards one end. I think the court takes equal amount of burden of the movement failing. Or
Let's get to the court judgment then. Now that we've got to the judgment, right? I mean, I think what those of you all who follow the judgment will, of course, know that there's a majority and there's a minority judgment, right? And Rohin, can you tell us a little bit, of okay, maybe I'll just make 2 points on the majority and the minority judgment, and you come in, right?
but there's no majority and minority,
Go on, yeah, go on.
right? So there's as Chief Justice Chandrachud famously walked in and said, there's certain level of agreement and certain level of disagreement. So all 5 judges, for example, say that right to marriage is not a fundamental right. All 5 judges say that within the existing framework of Special Marriage Act, we cannot grant you the right to marry. But at the same time, they disagree on a certain things, right? So for example, they say, well, Justices Chandrachud and Kaul say we can give you, the right to civil union may be possible in the future, but it is for the legislature. Justice Bhatt says, no, you even can't give that. And Justice Narasimha is on his own tangent, sort of talking about culture and society without dealing with the statute at hand. So I'll talk about these 4 judges. And then the final issue, of course, was of the adoption guidelines, where the majority says no and the minority says yes. Now, when this judgment comes out, right, it runs into, again, 300 odd pages. I've sat with multiple lawyers while I was writing the book and since after, and none of us can come to a consensus as to what is the majority judgment. None of us can come to a conclusion that what is the minority judgment. We can, the way it has been going on with all of us is that we put a proposition, and then you read the entirety of the judgment, and then you try to, by deductive logic, by inference, try to find out what the answer to that is. So, I don't think there is a majority or a minority judgment in a very technical legal sense, in that there is no ratio per se.
Yeah, no, I think we can have a long discussion on this point. I would take the viewpoint that there is, in your words, points of agreement, points of disagreement, that the judges agree on the fact that there's no fundamental right to marry. The judges agree on the fact that the Special Marriage Act cannot be interpreted to include same-sex relationships, etc. And the judges agree on the fact that marriage, transgender people in heterosexual relationships are entitled to marry. Those points, 3, and the judges also agree on the fact that in Rohin's title, that the LGBTQ community is not an urban elite phenomena. Those are the points the judges agree upon. Where the judges disagree would be the 2 points, which is, I would say, the minority opinion, which is on the question of adoption, where the question of what you call relationship recognition, or the right to union, where the midpoint between marriage and nothing is the minority opinion, which says that the committee should be constituted to look into the possibility of recognition of the relationship between 2 persons, which would be a union coming under the Article 19C, but not marriage. That's one point, the minority. The second minority point, of course, is the adoption question, where the judges recognize the fact that the minority opinion reads, they say that, that we should read down the regulation in Kara, which basically says that the only people entitled to adopt are people in a stable marital relationships. The minority says it should be people in a stable relationships. Why have marital? Because there are enough people who are gay, who are lesbian, who are great parents, who are doing a good job parenting, etc. But the majority, of course, doesn't agree on these 2 points. So that would be my way of thinking of the majority-minority. But if you want to comment on that, please comment. But otherwise, the question...
comment is that, right? You throw something on the wall and hope that it sticks. I don't think they lay down the propositions clearly save and except for the fact that we can't give you the right to marriage. I don't think the majority and minority spell it out in so many words.
I think we'll have to disagree a little bit on that, because I would say that there are the points on which there's a majority, the points on which there's a minority, and the points on which there's a consensus. All five of them agree on some points. Right? That's a way to, I'd say, split the judgment up, into three possible ratios which are there in the judgment. But yeah, we'll leave because we have I think, an audience which is partly lawyers who I'm sure will jump into this discussion now, and partly non-lawyers will be like, guys, can we move on? There'll be that part of the audience as well. So, on the moving on question, Rohan, the question, again, the point being, right? I mean, going back to the question of Rohan's point that, see, it's okay to say 3 years is too short a period of time, but 3 years, a lot can also happen. He's right. A lot can happen in 3 years. And I also think a lot did happen, And my point on what the lot which did happen is, again, you go back to the case, right? The point being that there were, over a period of time, again, the case is initially filed by a couple of people, a range of other people joined the petition. So end of the 19 plus, I think, petitioners.
20 petitions, 54 couples.
20 petitions at the end of the day. And the petitioners are lesbian, gay, transgender, intersex from across the length and breadth and the diversity of the country. And across the diversity of various kind of strata you can think of, in terms of sexuality strata, in terms of class strata, and perhaps Rohan cites this in the book. I think you say it as well. The person who, you don't quite put those words, but the lawyer who kind of captured that quite well was, do you want to tell the story?
Raju Ramachandran?
Yeah, you want to tell
Yes, so Mr. Ramachandran began his argument by tracing who were the people in this case. So he's talked about this couple, Bhavna and her partner, one of whom was an OBC woman and the other was a Dalit woman. One of them worked in a bakery. And then he sort of joined the ends, as it were, with Vivian Bose's famous words that the Constitution just does not work for the mighty, it works for the butcher, the baker, and he said, and the candlestick maker. And he said, well, that Vivian Bose was talking about a baker and the Constitution working for the baker, and here's a baker before you today who wants her right to marry.
That was a fantastic kind of displacement of that urban elite kind of phenomenon. So that, I think, happened very well. And again, I think there's in terms of your future writing, there's a future book there, right? In terms of if you're thinking of a story, which is the story of the petitioners, right? And Rohan is one protagonist, of course, in it, but as Rohan is indicating, the range of other protagonists in terms of people who filed the petition. So I was just thinking, what a fascinating story to get, Bhavna and her partner, right? That narrative out. And why that is so important is, again, going back to the point that the battle is not done. The future is still very much open-ended. We don't know which way it's going to go. And if we want to place some direction in terms of pushing it in a certain way, I think telling those stories is very important. Again, one last point I'll make on this, which is the idea that why I raised the point of the movement question is not necessarily to say lawyers failed. That was not the point I was making. But to make the point that sometimes the wider social or political imagination matters deeply, the way judges think and the way lawyers are able to make out a case. And the wider social and political imagination is to establish the idea that it's perfectly natural or perfectly normal, to use those words, perfectly without question for two men or two women to be in a relationship and to have kids, right? And that's perfectly natural and normal. And that state, I don't think we've reached as yet. So the idea that, Justice Bhatt, who's otherwise, again, Rohan made this point, Justice Bhatt, who's the author of the majority judgment, since I excuse me for going on about majority and minority, though you don't agree with me, but since Justice Bhatt, who authored the majority judgment, is otherwise a very progressive judge, otherwise, right? And you've seen, for example, Rohan mentioned, the judgment came out, I think, just a week after that, right? A week after that, actually a very progressive, very, very important judgment on the manual scavenging question, right? Where Justice Bhatt passes a series of directives which he completely denies to queer people for people in manual scavenging, right? There he has no problem passing different kind of directives, but in this case, he, again, going back to the point which the book makes very well, is the Justice Bhatt basically expresses all the sympathy, but gives you no relief.
If I can just step in here. It's like this one of the review petitions. Udit Sood's petition says that the judgment gives us all felicitations, but then says, thank you, come again next time. So it's sort of that. But speaking of review petitions, as I was coming here today, we got the news that the review petitions are listed the day after at 1 o'clock. So although they're going to be heard in chambers, by the end of the day, on the 9th of January, we'll know which way the movement's going.
So we've talked about in a sense what I think, right? The value of the entire marriage litigation process and the live streaming part, I think, right, was the fact that, it took the matter to wider public than any time in the past. And if you're thinking of changing public opinion and people's perspectives, this was an opportunity. And the process might have begun, but it's nowhere near ended. So there's a lot more work obviously to be done. So this is the more complicated question. What is the way forward from here, right? If you think, again, I'm asking you to think a little like a lawyer, which of course you are, which is 5 ways, 3 strategies, which you can think of.
I only have one strategy, and that is for a person to not decide what the strategy is. I think there has to be now a national consensus building on what is the way forward, right? The demands are vast, the demands are diverse, right? What you need currently in Manipur is very different from what you need here in Bangalore. So in that case, I don't think it's possible to come up with, say, a fixed set of demands per se. But then we have to agree to pursuing certain issues and agreeing to pursue certain issues in the future. Now, what those issues are, I don't think it's for one person to decide. I think it's time for a national conversation on what should we do. Conversations have broken down within the movement. Conversations have broken down on various lines. And so the time is now for all of us to realize that we have far more in common than that which divides us, right? And to come to a table. Look, we can disagree. We can come to a table and disagree on what to do. But we don't have to disagree on the fact that we all need to come to the table. Even when 377 was happening, for example, there were groups that were holding national consultation, right? People from across the country would fly in, they would talk, they would disagree. That's fine. Which great Indian family does not fight? But at the end of the day, we are all in it together, like every other great Indian family, going back to your idea of love, albeit a different kind of love here, is that you fight and you scream and you shout and you sue somebody else. But at the end of the day, whenever there's a family wedding, though not necessarily a marriage, you come together again.
So, okay, fine. So the answer which I think Rohin is giving us is, firstly, of course, in a movement there will be multiple responses. And who am I to give you all the possible responses? And but I was also trying to push towards the idea that, what are the possible strategies? Just to think in terms of what are the possible strategies. I'll place maybe one and tell me what you think of that. And maybe we'll take it forward from there, right? One is the 2 ways forward which are already there, right? Which we are engaging with. One is the idea that, you have a Supreme Court judgment, which is tragically, it's a 5 bench decision, right? So overturning it needs 7 judges. So considering a 7-judge bench might never be a easy thing. I think if I remember, Chinnaya, which is the internal reservation matter, was a 5-judge bench, overturned recently. It might have taken 17 years for that overturning to happen, if I remember. So if you could look at that time span of how can you turn a 5-judge bench into a 7-judge bench judgment, that might be a long time in the future. That's one kind of a possibility in what we think about. That's one. The second possibility, again, which I think a lot of people have been toying with in different high courts, is, fine, we have a Supreme Court judgment, which is there's a majority and there's a minority. So is there a way in which we can push the boundaries of what exists? Are there, for example, the incremental strategy? Are there minor ways you can push the boundary in different cases? The third possibility, again, you comment on all of these. Huh? I want to comment on all of these. The third one is the question of, there's a high-part committee which is supposed to be constituted post the judgment, which has actually been constituted. Again, there are a lot of questions around that committee because think of it. You consider a committee post the judgment, and does the committee include any of the petitioners? Does the committee include any of the lawyers in the petition? No, as far as my understanding is.
They were
Huge
invited.
problems.
Some of the people who were petitioners were invited.
Some, okay.
But the initial set of discussions happened in closed doors, and only when a huge hue and cry was raised about why these discussions were closed that the doors have now been opened to a broader conversation with the community. But it's also classic Indian bureaucracy, right? You talk at the people, you don't talk with them or talk to them.
So the third strategy, which is there, is what happens through the committee process, right? I'm just thinking that, we have some kind of a guidelines, notifications which have come about. One, for example, the fact that LGBT prisoners, right, are entitled to visitation rights regardless of sexual orientation, gender identity. I don't know the exact language, but that's the broad kind of a point seems to be made. That you're entitled to open a bank account regardless of, again, sexuality, gender. Again, that you can argue that it existed in the past, but that's a guideline which is there. And I think one on police violence harassment, again, a guideline which has been issued, or notification which has been issued. So a couple of notifications which are there. Again, we have to consider how is it possible to take forward these, for example, notifications. So three broad points. And the fourth point might be, right, how one thinks of, again, all the people involved here, how people can get involved, what are the possibilities which are there in terms of what people can do to try and push the boundaries, as it were. We might not be able to push the boundary of the big Supreme Court judgment at this current moment, but are there small ways in which can begin that process of social, political, cultural transformation, right? And that's the context in which I was saying, Rohin, the book on the 19 petitioners is a very, very important one. Because that's a way, and forget that book, your book is a very important one. It's a very important one for the simple reason that it's in the middle of the struggle. And we hope, and I know it will happen, people will read this book, people will get inspired, people will take things forward with this book. And that's important. If this wasn't there, then there's a way in which you don't create the possibility of a future. And so that's a very important step in that direction. So I just put forward some ideas. Go ahead. Yeah.
For 4 points, and I'll address one of them systematically. I don't think the battle before the 5-judge bench is lost yet. Reviews are pending. Reviews will come up the day after. Reviews are dismissed. We'll file curatives. Now, second thing.
That's a plus one.
That's a plus one. Super. Now, assume that even the reviews fail and the curatives fail. All you need to do now, post the AMU case, is to get a 2-judge bench of the Supreme Court to doubt the 5-judge bench and refer the matter to 7. Devinder Singh happened pre-AMU, right? So now there's a radical possibility because earlier the case had to work itself from 2 to 3 to 5 to 7. Now a 2 can directly refer a matter to 7. So that timeline might slightly be crunched, possibly in my view. If that does not happen, we still have the legislative route open.
That's the other point, yes.
Right? Write to your members of parliament. There are far more people today who are queer friendly across party lines, who may not willingly take up marriage, but will take up other issues, right? One would have never assumed that the Home Ministry, under who it is, would have said, well, grant conjugal rights to queer and trans prisoners. So there are common issues, low-hanging fruits that you may, given a sustained political movement, be able to get. Your second point about high courts. It is succeeding in some cases, it is not succeeding in others, right? So, for example, on issues of horizontal reservations for trans people, it's a movement which is succeeding in some high courts, not succeeding in some high courts, is in sort of this weird limbo in others. But insofar as relationships are concerned, people are getting protection orders, but not the logical sequitur, right? We had the recent case where a partner was not given dead body of a family that had disowned him, and the body was handed over to the family that had disowned him previously because of a very simple nature that we carry the 400-year-old law common law tradition, which only recognizes marriage in the form of blood, adoption, and marriage, right? So relationships are only recognized in these three forms. It's also my answer to the anti-caste critique of marriage, that unless we have a radical reimagination of family law, which will not happen overnight, but it has to happen at some point, marriage is the best that we have. It's like what Churchill said about about democracy, that it's the best we have, but it's also the worst that we have. Your third point about the administrative committee. Now that committee can only deal with so much and no more. That committee is limited to issuing clarifications, issuing directives, right? Even then, the government has a majority there. Lawyers are supposed to be invited as special guests to those committees or special invitees to those committees and not given a full-time membership of that committee. Again, there are various problems with the committee, including, the fact that they have had NGOs with, NGOs and think tanks which are not within the remit of the committee, but they are still present there. Be that as it may. And your fourth point about what next and how can you get involved is, I think, you don't need to get involved at a very large level, right? Change does not have to happen overnight. Change begins like charity at home. Winning hearts and minds, I think, may be a broader political project, but it also starts within our own houses, starts within our own families, within our own social circles. So that's where you start. That's where I think a lot of us have started, and we have started, but we're nowhere near the end of that project. So, slightly long-winded answer to your...
Thank you. I think that's a useful discussion to have, because we got some 5 points and you responded to each of those, very important. And what's the time like, guys?
7:24.
No, I'm just wondering the way we can open it out then, yeah? Yeah. Sure. Or we can open up another 5-10 minutes, I think, yeah? We'll do that. Just maybe one last point and then we'll open it out, yeah? See, again, as you can imagine, right? Rohin comes with a certain radical imagination in terms of a certain kind of critique of a range of institutions which exist, right? Yet at the same time, Rohin has been part of the marriage equality petition. And I think the ways in which the book traverses that point and says that what does marriage equality actually mean, right? And that's the title of the book as well. If you look at the title of the book, it's the unfulfilled constitutional practice, promise of marriage in brackets equality. And this has been I think, right, issue of great debate within the community, very passionately and rightly passionately held opinions on all sides of the spectrum. People feel passionately and strongly about marriage. And people feel passionately and strongly saying that, what the hell is this marriage between two persons for life? There's other forms of relationalities, other ways of being which are not recognized by the normative institution called marriage, right? And Rohin is, I think, in the book, negotiated this, you want to call it dilemma, this kind of a way of thinking, in terms of the way Rohin understood, in my understanding, the idea of marriage. Do you want to talk a little bit about that?
I don't think for me it's about marriage.
Yeah.
For me it's about equality, right? I don't want to focus on marriage. I think what is marriage is for two people in that relationship to define for themselves. The law may not recognize, for example, open marriages, but so many people I know are in open marriages, right? The law may, for example, not recognize a polyamorous relationship, but so many people I know are in polyamorous relationship. You need to understand, and this is a point I talk about at some length in the book, is that queerness is amorphous, and the law seeks conformity. Much of the work that you do today in court is to, given ABC facts, which case does it fall in? Is it, say, Section 86, Clause A, Clause B, or Clause C? Is you try to pigeonhole a given fact situation to to a legal proposition. Now, something as fluid as queerness, something as amorphous as it, you know, how do you regulate it? I think for me, the shining example of this is the debate over the Trans Act and how the Trans Act and the trans bills over the years have sought to define what is a transgender person, right? The answers is perhaps not resolved even within the Act today. One of the major faults with the Act today, on which it's also being challenged, is that it clubs trans and intersex people together, right? So how do you kind of bring method to this madness that is queerness? And I don't think you need to, right? And I think as time evolves, the law will evolve. But until then, it's about equality. If nobody's going to, the moment marriage equality is there, I think one of the people, for people who want to reject marriage, they have the freedom to. Marriage equality does not mean every two queer people in a relationship are going to be married off. But at the same time, there are anti-caste and feminist critiques of marriage, and they are very valid. But like I said earlier, that unless we have a radical reimagination of what marriage is, and a radical imagination of the common law that we've inherited from our colonial past over the past 400 odd years, we have this to work with. How do we, for me, I think the centrality of Part 3 of the Constitution, the chapter on fundamental rights, is the Equality Code, Articles 14 to 18. Should you not have that, everything else falls. So the idea is not to focus on marriage in the debate around marriage equality, but to focus on the equality portion of it. Marriage is a faulty institution. Marriage will amplify, marriage will perpetuate caste and class-based endogamies. I don't think anybody, who studied basic sociology can contest that claim. But in the meantime, there are cases where bodies are not being handed over, where two people who are cohabiting with each other are violently separated by their families or by the state. You have cases where, some of these petitioners, one story that kind of turned me into somebody that had in past opposed marriage equality was the story of this gay couple who was also a petitioner in this case. One of them was an NRI, the other was an Indian citizen. Now, during the pandemic, one of their parents fell sick. Now, this partner was not able to accompany the other to take care of his sick and ailing parents, right? So this mutuality of affection that you are able to give, because marriage is, in as much as it is a social institution, it's also a legal institution that creates rights, duties, and obligations, not just between the two parties, but also between the two parties and the state, between the two parties and the society at large. So, for me, the focus is not on marriage. Marriage is a faulty institution. I begin with that premise. But for me, it's about equality.
I think that's a very interesting answer. Again, what I understood, right, with the point which Rohit is making, is if you think of two principles in the Constitution, which is liberty and equality, Rohan's point is a simple one. If two heterosexual people can get married, why not two gay people? So that equality principle is what you're drawing out. The liberty principle, which you're also invoking, would be that you are anyway free under 21, the idea of real liberty, to form the kind of association you want to form. There's nothing preventing you from taking the form of association form. Which is?
The judgment.
No, but the judgment doesn't allow for marriage. That's your point, right?
Well, you see.
Yeah, but I'm saying the idea of a relationality, which is inside or outside, without rights concomitant to it. But that's your second point. Your point is that all that is great, but rights flow out of relationships. What about those rights? That's your second point.
Yes,
yep.
Because at the end of the day, a bureaucrat sitting in a sub-registrar's office where you go to get married, as a trial what we did was we sent our clients to, so we were representing two couples, one under the Foreign Marriage Act and another under the Special Marriage Act. Both of them have very similar provisions in how you get married. In one, you go to the sub-registrar's office, but in other, you go to the Indian embassy. So we sent our clients and said, well, why don't you try and go and register and see? Now, under Section 17 of the Foreign Marriage Act, they're supposed to give you in writing the reasons for refusal. These are never given to our clients, right? So at the end of the day, rights and duties sound fancy on paper. They sound fancy in conversations like these. But at the end of the day, you need that piece of paper to enforce those rights.
No, yeah, thank you. So what I think we'll do now is we'll open it out to the hall as a whole. Just maybe two concluding comments. We were talking about, in fact, with Jaina Kotari is supposed to join us, but not able to join us today. And Jaina asked Rohin, what's the title of your book? Rohin said, the title of my book is Urban Elite was the Union of India. Jaina said, Rohin, that's you, always provocative. So that is Rohin for you. And we hope that all of you guys will pick up a copy of the book, and Rohin will be signing the copy outside. And as I've already said, it's a fantastic book. Please do read it. But now we'll open it out to anybody else who has any thoughts, questions, etc. Yeah, please, Suraj.
Thanks. I really love this conversation. But I have a thought or a point, like in the fact that after Section 377, why was the jump into marriage equality coming in when there could have been a lot of work could have been done in terms of laying the foundation for, I know sensitization and all of that was done. Why wasn't there a law which was there to protect people against discrimination, right? Wouldn't that kind of be like a step forward in getting marriage equality also done? Because now, even if marriage equality has to pass, now there can be ways of discrimination happening there as well, right? So why wasn't that as a step thought forward instead of marriage equality? Just your thoughts and views.
Well, I don't think marriage is the only thing that was done after 377. Petitions were filed challenging Trans Act. There were petitions across the country on horizontal reservations. These are petitions and issues that have kind of escaped the zeitgeist because, they're not sexy. They're not fancy as marriage is. You don't get a lovey-dovey reel out of a reservation case. And so several lawyers across the country, including Jaina, have been working very hard on a range of issues from accessible care to reservations in employment to reservations in education, so on and so forth. Now, your question as to why did we not do anti-discrimination, I think, like I said, like when the petitions were filed before various high courts, nobody thought that they would jump up the ladder and they would, bypass several larger constitutional issues that were then staring the court in the face, some of which have since been resolved. Whether rightly or wrongly is a debatable question. But you see, why did we do a thing A and not a thing B? There's no answer to that, in my opinion. Calls were taken for whatever reasons they may have been taken to pursue a cause, right? People don't pursue causes for, what's the phrase? People don't pursue causes haphazardly. When the first petitions were filed, lawyers that may have filed the first petitions may have had something in their mind. And so, I think your answer to why did we do A and not B, I think A and B are not two things that are mutually exclusive of each other. Rather, they are two things that have to work in tandem with each other. The problem with the framing of these issues has been that we have not sufficiently tied the cause for denial of marriage equality as a cause for anti-discrimination?
Maybe just one thought I'll add to that, which is that when you say why didn't, there's an assumption that there is a we who can respond in a unified fashion. And give maybe a comparative example. And the question came up in many jurisdictions around the world, right? Justice Kirby was narrating the story how in Australia, the entire question was post the entire question of decriminalization. They had other strategies, other precisely what he said, non-discrimination. But then always there'll be one gay couple or one lesbian couple who somewhere say, I want to get married. That's also that dimension there, right? And nobody's blaming anybody for the simple reason that hopes have been liberated, imaginations have been opened out, and people feel it's possible. And this is what they passionately desire or they passionately want. So there's nobody holding a whip, and saying, hey, you don't file this petition. If two people want to file a petition, it's a free country. They will file a petition, Yeah, please.
So my question is that since for the current political party, a uniform civil code seems to be another big move, and it has been there in their, say, for buying votes. And a couple of states, like I guess Uttarakhand, have already passed guidelines for UCC. How do we imagine the entire narration or the entire narrative from now on for the movement will change if UCC ever comes or if it manifests in reality?
Now, you see, very interesting question. I think the limited political imaginations of the powers that be works to our advantage in this case. So if you look at how the Uttarakhand UCC defines a live-in relationship, right? It talks about a heterosexual relationship. That leaves queer couples out of it, right? Unless you are, as the Supreme Court puts it, transgender person in a heterosexual relationship. So long as this is not coming to bite us in our backsides, I think us being left out of the UCC due to limited political and legal imaginations is a good thing. Now, the larger debate as to why UCC, I think unless we have a draft of the UCC in front of us, is very difficult to debate, or why not UCC is very difficult to debate. And this is only UCC about family law, right? We already have a civil code in terms of contract law or in terms of dispute resolutions arising out of contracts. So until we have stuck to this notion of this UCC as enshrined under Article 44 and then subsequently its reading in Sallam Mudgal and so on and so forth, I don't think queer people are at a risk of coming under the UCC. And I think this is one of the rare cases where being left out is good.
See, it's a complicated debate, I think, the UCC debate. And obviously, there have been different responses to the UCC at different points in time. The early feminist response was completely in favor of a UCC. Because again, what is the idea, right? The idea that it's not necessarily what you'd call a UCC, you'd call it gender just law. Of course, the law on marriage and divorce, etc., should be gender just. There should be a certain kind of a equality, a parity between the different genders. But of course, the debate took a different turn with the push of the right wing in terms of pushing the entire question of the UCC. And so then the right wing owned the issue, and the space was in a sense vacated by the feminist movement at that moment in time. But I think now the debate has come around in terms of people are looking at the question that should we not intervene in the current UCC debates. One strong opinion which Rohin indicated is one saying that, let's not talk about the UCC. That's a strong opinion. Let's not because we can't, it will be a disaster. And that's, I think, in the political context, one understands that fully. But the other viewpoint is to say, can you intervene in the UCC debate and push it in another direction?
But to what end,
In terms of, I'll just finish with one point. In terms of the idea that, so far the UCC debate, right? If you look at the various drafts, none of the drafts has had this question of, relationships for the same sex or the same gender, etc. Right? So is there you put that proposal in, are you setting the proverbial cat among the pigeons? Are you saying that, hey, this is what you need to engage. You want a uniform civil code? What it has to be a gender just law, point one. Second, it has to be inclusive sexual orientation, gender identity. So I've taken the exact opposite position from you on this. Yeah.
But you see, it's very interesting because you look at the Uttarakhand UCC and a couple of other UCC drafts, for example, right? One of the things that is implicit in all of this is parental consent. Are you then going to force queer people to come out to their parents to get that parental consent and to be in a relationship and to be in a live-in relationship, and how feasible it is given our violent context?
I completely agree with you on that. I'm saying that is there a space for that, for interventions by queer groups? Would you put in a draft on saying what is your imagination? There's a chance, right? Put in your manifesto. What should a ideal relationship be? What should the ideal kind of a family law regime be in your mind? And I think there's a chance to put forth that imagination. But completely with you, agreeing with it, that should be challenged. 100%, yeah.
One of the rare things about being on a panel with Arvind is that you almost always agree on everything. The conversation.
Hi. Just going back to what I think Rohin was saying about next steps and also building consensus. Do you think it's useful to continue arguing it in the court rather than like building consensus and moving towards the parliament and getting something done there? Because as you said, courts continue to be fair weather friends, and depending on the masters of the day, we've had various kinds of judgments come out. So what do you think?
I don't think the two are exclusive of each other. Just because you're, arguing for marriage equality in courts does not mean that you don't have to argue for it in parliament or in the public opinion. Both of these things have to happen simultaneously. Social movements are not unilateral. They have to operate on a multi-axis framework across various tools that are available to you: peaceful protests, lobbying parliament, lobbying the courts, arguing cases in court, bringing about change in public perception through a popular movement, so on and so forth. I don't think they're exclusive of each other. I think they have to the contrary, they have to happen together. And more often than not, whatever gives you result, the sooner, right? So assume we also had a bill in parliament that may have miraculously passed. These cases would have become infructuous, and then, we would have lived on to another struggle. So they're not in conflict with each other. The problem happens is because we're operating on very limited resources. We're operating on very limited manpower, financial resources, and political mileage, right? And in today's day and age, courts are increasingly becoming aware of the kind of political capital and the limited political capital that they have, and the issues on which they want to expend that said political capital. So perhaps now there are certain issues for which courts we've been fairly successful. Say horizontal reservations. Most cases have resulted in not the law being settled down, but ad hoc reliefs granted to the petitioners that have gone to court. Similarly, there are times when one solution may not work out, and then you will have to, say for example, the Trans Act, right? The bill was rammed through the parliament, and now what are we left with but to challenge it in courts, right? The reverse with marriage equality. Now that the decision has gone against us, what are we left with but to sort of appeal to parliament? So the question is only what solution works out the first.
Just to add to that, one is you think in terms of Supreme Court and High Court, and of course Supreme Court might be more challenging currently, but the High Court, for example, even post the judgment, there have been a range of very progressive judgments from various high courts. The Anand Venkatesh order in the Madras High Court, which has recognized the idea for what you call a deed of familial association. And the judgment specifically says these are the limitations imposed by the marriage equality judgment. But what we can do within that frame is recognize possibly a deed of familial association. That's one kind of an argument. The second is sometimes you don't have a choice. If there's a couple which has been split up and there's a the parents have taken away one person, you have to go to the High Court and file a habeas corpus petition. And the case which Rohan mentioned as well, the case in the Kerala High Court, which is the case of this gay couple, and one of them tragically fell off the terrace, I think, and he was taken to the hospital, and he tragically died in hospital. And then the question was, I mean, the partner said that, I mean, can I have the body, right? Can I pay my last respects, etc. And the court, basically the hospital said, we can't give the body. Who are you? How can we give a body to you? Just some arbid person on the street. We can only give it to the family members. But the judge intervened, and I think the lawyer, we met the lawyer here, right?
Yes.
In the meeting.
Yes.
Right? The judge intervened, and we had a very good lawyer from trans lawyer, if I remember, from Kerala, and they managed to work with the court to get an order which allowed the person to be there at the funeral. But again, see, the limitations is to not the body released to the partner, but for the partner to be there, the body being released to the parents. That's the way it worked. But I'm saying you don't have an option many times, but to go to the court.
Hey, hi. So I had a question about something that you said in the book, which is, I think you were talking about the voices that had condemned the way that the petitions were handled, and you said this is not the time to assign blame, but to feel queer grief as a community. Oh, sorry. But you talked about how this is not the time to assign blame, but to sort of collectively, to share in our collective queer grief and to work on strategies to fight back. And I was just a little confused about, how do we imagine... Okay, let me just frame my thoughts a little bit. If a grief... So I experienced no grief from the marriage equality judgment, I'll be very honest. Because it was not a fight that represented any of my interest. It was not a fight that was done with any consultation with me or with the people that are part of my queer family or whatever. It was not something that I had no horse in the race, so to speak, right? But if we are imagining this as a collective queer grief that the entire queer community feels, is there not a need to understand how we came to the position where we're supposed to be grieving a decision that we were not a part of making in the first place? And how do we prevent this kind of grief coming our way going forward? If it can happen now, where decisions are made by certain people from the community or certain parts of the community, and the rest of the community has to grieve for it, what is stopping it from happening in the future?
No, I think definitely. I think a lot of people felt that they had no horse in the race, and for right reasons. I do think that part of the blame is to be taken in the ways the petitions were filed, and this is something I've been critical of even in the book. Why I talk about our collective queer grief is that whether or not one had a horse in the race, to borrow your phrase, is that the jurisprudence will affect you, right? So the idea then is to not sit out the petition, or to ignore the judgment, because it's at the end of the day a judgment of 5 judges of the Supreme Court. It's a major thing to happen to the community. But to acknowledge that the judgment has left our rights poorer. I am not for a second saying that, the petitions were filed correctly. They may not have been, and there are 2 views about it. But at the same time, one of the things that you have to also see is that in the case before the Kerala High Court, the union had filed an affidavit saying we are going to ask all the cases to be transferred to the Supreme Court. And that's also part of the nature of how our judiciary is structured. The Supreme Court is in Delhi, and so by the very incidence of geography, Delhi sort of gets this prime place in the juridical polity of our nation. But having said that, I agree with you. I agree with you that the litigation process, insofar as public interest litigations are concerned, has to be more consultative. It has to be more participative. But at the same time, there's a second view on it, one that I don't necessarily agree with, but that it does exist within the large sections of the society. And this view is that if my fundamental rights are encroached upon, I shouldn't have to ask anybody before going to court, right? But at the end of the day, we are all in it together. The jurisprudence that is laid down, and especially when the movement is far more litigious than it should be, then I think whether you like it or not, that litigation is going to affect your life, right? You can't sort of say that, well, I had no horse in the game, so I'm going to sit this one out. Consider this, right? The Kerala High Court case. For all reasons, there may have been people who may not have sort of felt one with the cause, right? I don't know that, I can't speak to that, but let's take it as a thought example. But will the decision not have affected their lives? And will it not affect all of our lives, right? Under Article 141 of the Constitution, for example, the law that the Supreme Court lays down is the law of the land. So the idea is not to reject litigation in the Supreme Court or to reject litigation as a strategy, but to give a call for a greater movement of participative litigation, to give a call for a greater site where community members, activists from the community organizers, community-based organizations have a greater voice to play, right? And that has to begin by getting everybody to the table. That has to begin by negotiating with ourselves that even those that we violently disagree with and vehemently disagree with, we might be able to find common cause. And that is not to say that we get everybody on board. So for example, we must obviously reject Islamophobia, transphobia, classism, disability-based discrimination when these conversations are held. And again, that is not for somebody like me who's primarily based out of Delhi to decide as to how these conversations should take place. These conversations have to happen not from top down, but they have to happen from bottoms up, right? So it is for each of us within our local communities, within the people around us, to decide what causes we want to champion. In court, outside court, in the court of public opinion, in the political arena. And at the end of the day, like I said, in conclusion, even when it is not done with taking people into confidence or taking people into consultation, it will affect you. And it will now we've come to this weird position where the court has said that indirect discrimination of queerness is legally permissible, right? So now, tomorrow there can be a statute which leaves out queer people, and the court may very well say, well, we refuse to read you into it, basis the superior judgment. So the idea then is to find out where we went wrong and come together as a community, build bridges. I think there are far too many bridges that have been burnt down. There are far too many far too many bridges that have been burned down. And that is not to say disagreements should not happen, right? Like every political movement, like every social movement, we will not agree on anything. But at the end of the day, even though our imaginations of equality may be different, we're striving towards equality. And I think that is the common thread that should bind us all.
I think then on that really wonderful note, I should just thank Rohin for building this really beautiful rainbow bridge for all of us to walk on. And thank you so much for both the book and for the work that you've done in all these years. And we look forward to many more books and many more years of work. And please join me in a round of applause to Rohin and the fantastic work they've done.